Hey everyone, welcome back to SecureDApp's YouTube channel. As always, this is your host and host Kunal, and today we are back with SecureDApp Spotlight episode 4. So, what is SecureDApp Spotlight? SecureDApp Spotlight is a series where we sit down with industry experts and explore the latest blockchain and cybersecurity regulations and whatever that comes in between. Real insights, talk straight from the front lines of Web3 and digital security. So, without wasting any further time, let me just introduce myself. I am Kunal Chowdhury, Content and Community Executive and a subject matter expert at SecureDApp. With me, I have joined with Mr. Nikhil Prasad. Mr. Nikhil Prasad is one of the most promising legal minds shaping the future of blockchain regulations. At SecureDApp, Nikhil serves as a blockchain regulation and a subject matter expert, playing a critical role in aligning decentralized technologies with evolving legal frameworks. So, over to you, Nikhil. Let's just introduce yourself to the audience and tell them what we are heading to.
So thank you, Kunal. Thank you for such a wonderful introduction. So uh, everybody, I am Nikhil Prasad Singh, and I am a passionate lawyer, and my area of interest is crypto and blockchain and its regulations. So today we will cover regulations of Hong Kong and how they are evolving, and what are the developments that are happening within the past year, and what is the future of that uh, of the Hong Kong market. So over to you, Kunal.
Thank you, Nikhil. Thank you for the intro. So, coming to Hong Kong, how does Hong Kong licensing regime for virtual assets trading platform VATPs enhance investors' protection compared to jurisdiction without such framework?
So how does Hong Kong licensing regime works without a framework? That's what your question is, I think. Yeah.
Yes.
So you see, Hong Kong virtual asset trading platforms regime is not something that is unregulated. Okay, it has been effective from 1 June 2023, and it requires any platform offering crypto fiat or crypto exchange services for an automated matching engine. Okay, to obtain a license, and further, the platforms that operate before that date as well were deemed to be were stated that they are deemed to be licensed, okay, and granted a 12-month transition to comply with the full licensing requirements. And further when we move on to the latest development, the regime has also designed around four core pillars. First is you can say is rigorous token admissions and due diligence standards. Second is robust custody and asset segregation requirements. Third is the stringent cybersecurity assessments, and the fourth one and the most important one is enhanced government and disclosure obligations. So in this four security pillars, you will have to comply with all the these pillars, and of course there are further more due diligences within this uh, sub frameworks, but these are the most important pillars. So in contrast to unlicensed or lightly regulated jurisdiction where platforms are certified, may self certifies of their solvency, like they have no external audits. But so Hong Kong's licensing regime has some vetting applications, so it ensures some level of operationality. So, what do you mean?
What your point, Nikhil? So talking about Hong Kong, what are the key compliance challenges faced by the stablecoin issuers under the new HKMA licensing regime?
New key compliance challenges. See, as far as I know, on 21 May 2025, which is the just last month, man, the Hong Kong's Legislative Council have passed the stablecoin bill. Okay, that stablecoin bill mandates that any entity issuing or actively marketing referenced stablecoin in Hong Kong will have either it is onshore or offshore will have to obtain a license from Hong Kong monetary authorities. Okay, so under this regime, matlab, challenges, compliance challenges are various. First is there is reverse asset management. Second is redemption and liquidity stress testing. Third is risk management and governance. Fourth is the reporting, audit, real-time disclosures and all. If we go into deep down to all these pointers, we can understand that issuers must maintain a liquid, high-quality reserves asset equal to the 100% of the stablecoin outstanding supply. Okay, first of all, then licensing requires real-time redemption mechanism and at par value, implementing scalable cold wallet to hot wallet pipelines that can process large volumes or large volume redemptions without market disruption is a logistically can honor redemption even under market moves as well. When further, the Hong Kong Money Authority as well insist on a sound governance framework including a dedicated board level stable coin risk committee. So that is how they have maintained their compliance challenges. And of course, if crypto is always associated with illicit activity, it has to given more compliance in such a nascent stage. So I think it's completely justified how much compliance they have made.
Okay, okay, Nikhil. So one more question that comes to my mind is how does PDPO, Personal Data Privacy Ordinance, address the data privacy concerns specifically to virtual assets transaction?
Hmm. How the data price works in virtual asset, na?
Yes,
So
the
when
Personal Data Privacy Ordinance I'm talking about.
okay, personal data privacy ordinance. Okay. So when we look at PDPO, that is Personal Data Privacy Ordinance, significantly it was amended in I think October 2021, and it applies to every data users, any data users controlling personal data collection or processing within the Hong Kong or outside the Hong Kong, and it includes virtual asset service providers as well. If they are providing their services, they will have to maintain some level of data of their customers, of their KYC mechanism, of their holdings, all that. So they also come within that data privacy framework. First of all, that is we have to look how it applies. So first of all, we will have to look the purpose of the act. VSPs uh, must only collect personal data that is for the purpose of directly related to the services, not other things. They cannot take information that are not directly related to those services. Further, they must inform users via personal information collection statement as well of the specific purpose. So that is how the level of personal data protection applies to the virtual digital assets as well. In the VSPs must only retail as also personal data for as long as necessary to fulfill the original purpose. And if the original purpose is not more required, not more uh, in functioning, they'll have to delete that data. So up to that level, they have gone. And when we talk about transparency, data protection ordinance also uh, grants individual the right to access their personal data held by the VSPs and to request rectification as well. So it is, I think it's completely applicable, and all those definitions come within the BA virtual asset service providers regime as well.
Okay, understood, Nikhil, understood. So after you answer this question, in my mind, I have just one more question that struck on my mind. So, in what ways do Hong Kong's AML CFT regulations for VASP align with the international standards set by the FATF that we call Financial Action Task Force?
Hmm. See, man, everybody will have to comply with FATF either today or tomorrow. Because if you don't comply with the FATF, if they put you in their gray list or black list, so you will have hundreds of thousands of sanctions. You will not be able to uh, what participate in the global trading, global businesses, exports, imports. So that up to that much. you will get hampered. Even when we talk about FFTF, India's AML regime is also because of the FATF. If FATF doesn't have given their 2021 guidance, there would not have been any compliance as to FIU in India as well. So when we talk about Hong Kong AML safety regulations for the VSPs, it is up to the international standard. First of all, there is licensing and supervision. So, so the trading platform, virtual asset trading platforms licensing regime effectively registers all those service providers under a formal supervision, satisfying FATF's requirement for VASPs to be licensed or registered and subject to ongoing monitoring as well. Further, FATF requires enhanced due diligence for high-risk customers and PEPs. Hong Kong AMLO and FSC guidelines mandates VASP to uh, perform what future contracts on all their clients. So FATF is completely, I think, functioning. All those AML regime of the Hong Kong is in compliance with the FATF as well. They have their record keeping mechanism must they in which they must keep their detailed records, transaction logs, and travel route data for at least 7 years, aligning with FATF's requirement to retain records for no less than 5 years. So I think FATF is completely applicable.
Okay. So, Nikhil, my next question to you is what are the implications of Hong Kong's tax treatment for virtual assets for the businesses and the investors?
Everybody has the same question. What are the implications of taxes? What are the implications of taxes? I mean, yes, there are some implications, man. Uh, in Hong Kong Inland Revenue Department, that is IRD, currently it does not impose any capital gains tax on profits from virtual assets. Uh, it is different from India. And however, income derived from trading, lending, staking may be treated as either trading income or profits or trade or professions, and it is subject to ordinary profits. Ordinary profit, that is like 16% for the corporate, 15% for the unincorporated businesses. And if the activity, your activity constitutes trade, if your activity constitute trades, it will be meanwhile a purely massive investment gain. Such a long-term holding and selling of higher prices are generally, I mean, regarded as capital in nature of capital in nature, and it remain untaxed. If you invest for a long term, it will be untaxed, and if you invest for a short term, so it's there is not that much it doesn't come under capital gains, but there will be some profit taxes around 15-16%. Further, if a VATP is operates as a market maker, and market maker means buying and selling crypto on its own account, such profit may be income taxable. Accordingly, operator entities often establish ring-fenced and cost centers to track proprietary trading versus customer facilitation to argue that certain gains are capital in nature. Okay, so there is not that much taxation regime in Hong Kong right now. If we talk about stable coins, so a stable coin issuance itself is not taxed. Any yield, any yield earned may be taxable if deemed arise from a trade. So only I think only trading is profit from a trade is something that is taxable right now. That too, if you get a profit.
What's your point, Nikhil? Okay, so one more point that comes to my mind is comparing to India, how does Hong Kong's virtual digital assets regulation approach stands out to be in this India's point of view, lands point of view?
So when we talk about Hong Kong, it's completely uncomparable with India. It's very far ahead with India. As of May 2025, Hong Kong maintains a comprehensive multi-layered regulatory framework encompassing the SFE's VATP licensing. HKMA's Hong Kong monetary authorities stablecoin regime, and PDPO secure formal license and comply with detailed on-site inspections, man, and their external assessment, periodic audits. It's nothing in contrast to the Indian regulatory landscape. Okay, there is no unified licensing in India. India lacks a formal licensing regime for crypto exchange or a service provider. First of all, second of all, India Finance Act introduced a classification for virtual digital assets. They have imposed a flat 30% tax on the gains and 1% TDS on all transactions, but does not regulate the underlying conduct of the exchanges. So you have a taxation regime, but you not have a compliance regime. You not have you don't have all the activities that can be regulated. So in perspective with India, Hong Kong is far ahead as of right now, man. That's what I think.
Okay, so you mean to say that Hong Kong is far away from India right now? But
Hmm.
I think India will match Hong Kong in few days. Hope so.
We
So
also hope
Nikhil,
so. I mean, bill is currently pending, so let's see within 2 or 3 years if it comes with a very proper regulation, everybody will be glad, man.
yeah, we as a Web3 community will be one of the most happiest one then, right?
Mm-hmm.
Okay, so Nikhil, let's move on to our next question. So, what are the measures in place to ensure the compliance among deemed to be licensed VATPs during the transitional period of Hong Kong?
Okay, so to be uh, uh, broadly, if I classify it for it's for those who were who were already in business before coming of the VATP licensing regime. They are considered deemed to be licensed, and then within next 12 months, they'll have to apply for the proper licensing regime. That's what the whole idea behind all those things were. Within the during the 12-month transition that ended on June 2024 last year, platforms that had been operating continuously since before 1st June 2023 were deemed to be licensed and temporarily allowed to continue services while preparing full applicants. Okay. So to safeguard investors during this transition, that's why these all deemed to be licensed things were introduced. And there were on-site inspections, there were conditional licensing, there were tripartite external assessments as well. So when I say tripartite, means there were three parties involved in that particular contract. So because to protect the investors' right, to protect the customers' right, and that why this deemed to be licensed regime was introduced. Okay, so from post inspection, all those deemed entity enter a tripartite engagement with SFC, and an appointed external SSF was also appointed. And up until December 2024, almost four deemed platforms successfully transitioned under this mechanism. So four platforms which have previously has deemed to be licensed now have proper license. So that is a very good thing to hear.
Got your point, Nikhil. So before moving to our next question, I would just like to tell something about SecureDApp, what SecureDApp does. So SecureDApp works as a frontline defense for your blockchain assets. It's a cybersecurity firm committed to provide security and work as a frontline worker for India's cybersecurity. And we have products like Secure Watch, Solidity Shield, Secure Trace, which are bang on with their working skills. When you just uh, put your laptop or your mobiles on the monitor key, then they will just identify the threats and notify you and defend your laptop, your computer from the threats. So if you want to know more, please visit our website securedapp.io. So moving on, Nikhil, moving on to our next question. How does SFC access the fit and proper criteria for licensing VATPs?
Mm, You see, when the entity submits a VATP license applications, the FSC evaluates both the corporate applicant and its responsible officers and manager in charges. Okay, so uh, they evaluates both the things, and under particular sections particular section 1329 of the Securities and Future Ordinances, uh, and section 553 of the MLO, considering that reputation, first of all, reputation, character, and integrity is judged. Uh, Second, qualification and experience of the ROs and MICs are judged. Third is that competence and the financial soundness is also judged as well. Okay, so there are many things that goes while managing an application. Okay, the firm and its controllers will have to must demonstrate adequate financial resources. Okay, the FSC's assessment considers whether the board and the sector executive have approved comprehensive risk management framework, and many more. Applicants submit a fit and proper questionnaire for every individual, with almost with more than less than 10%, more than 10% of the ownership, ROs, MICs, the FS, and etc. The FSC, then SFC, then conducts background checks, and may request additional documentation. Only if the SFC is fully satisfied on all criteria will it then it grants a license. Incomplete or substandard applications are refused. I have seen it getting refused.
Okay, Nikhil, understood. After hearing your point here, I have got a question that comes to my mind. So, what role does the Office of the Privacy Commissioner for Personal Data, that we call PCPD, play in overseeing the data protection compliance in WASPs?
See, the PCPD is an independent statutory body that establishes under the PDPO to monitor and supervise compliance with the data privacy laws. Its specific roles concerning the VSPs include issuing codes of practice and guidance. Although the PDPO is principle based, the PCPD publishes non-binding guidance and best practices, such as its data security measures guidance, which outline recommended safeguards for any entity handling personal data, including VSPs. Further, complaint investigation enforcement. If a user files a improper complaint, for instance, alleging improper data sharing or breach of DPDP1 or DPPP4 by a VATP, the PCPD can investigate, and if it finds any contravention, issue an enforcement notice requiring remedial action. Persistent non-compliance may lead to fines or, in severe cases, criminal prosecution as well. Further, recognizing that VASPs often handle both on-chain and off-chain KYC documents and wallet addresses and personal data, the PCPD conducts workshop, issue guidelines to educate VASPs on best practices in data minimization, direct marketing restrictions, cross-border transfer rules, and all that. And when we talk about cross-agency collaboration as well, so PCDP collaborates with SFSC, HKMA, Hong Kong Monetary Authority by participating in joint task forces. Okay, that develop cross-industry data privacy standard, especially around emerging technologies like AI-driven risk analytics, ensuring VSPs product adopt privacy by design principles when deploying on-chain monitoring KYC solutions. So, therefore, while the SFSC focuses on financial market integrity, the PCPD ensures that VSP respect user privacy rights, creating a balanced regime where security and data protection coexists.
Got your point, Nikhil. Nikhil, we have heard about virtual assets derivatives and margin trading. So, how does Hong Kong's regulations address the risk of that are associated with these virtual assets derivatives and margin trading?
So it's a very good question. I mean, it's a very deep analytical question as well. So in February 2025, the SFSC, that proposed a roadmap placed to integrate virtual asset margin trading and derivatives professional investors as well. It will be conditional and on a robust risk mechanism framework aligning with traditional securities practices. And professional investors on key measure their key measures were included professional investors only access virtual asset derivatives uh, are restricted to professional investors who pass stringent knowledge and experience tests. Uh, this model limits exposure to retail investor right now, unable to fully comprehend the high leverage and volatility inherent in derivative. First of all, this, and second of all, the margin financing standards. So when SFSC will require VATPs to set initial and variation margin level based on real time volatility metrics. Example, dynamic haircuts on collateral that are attached with 20% or more non-stable coin collateral and higher or low liquidity tokens as well. Third of all, VSPs offering margin financing must keep collateral um, in separately segregated accounts as well, with uh, daily reporting and real-time proof of reserve published on-chain to prevent committing of a client proprietary asset. Fourth, before enabling derivatives trading or margin financing of for a client, VSPs must conduct a thorough suitability assessment covering network checks, risk tolerance questionnaire, and mock trading simulations. And to ensure the client understand leverage risk, platform must also display real-time implied volatility metrics and maximum loss induction indicators on their user interfaces as well. So these are all safeguards aimed to prevent the excessive leverage and liquidity crunches that can cascade through markets. And by aligning with global best practices, such international organization of Securities Commission uh, methodology guidelines, Hong Kong ensures that margin trading and derivatives do not undermine overall market stability.
Got your point, Nikhil, bro. So, Nikhil, the last question of this episode. So, how is Hong Kong positioning itself to remain competitive in the global virtual assets market amid the evolving international regulations that we have from FATF or be other
So Hong Kong strategy includes a roadmap that I just talked about. First of all, there is a product diversification by permitting virtual assets derivative and margin trading for uh, derivative and margin trading for all professional investors, along with spot ETFs, taking services, and stablecoin issuance. Hong Kong broadens its product suite beyond spot trading, aiming to capture an estimated USD 70 trillion in global trading volumes. Second of all, the SFC has streamlined licensing via a swift licensing process, that is global VSPs to include established regional headquarter functions in the Hong Kong. And HKMA has a stablecoin sandbox and clear legislative timetables as well. They have a very good tax incentive framework. That is, Hong Kong is introducing tax incentives like extending preferential fund tax treatment to virtual asset funds, offering carried interest tax advantage to ASP's affiliated fund manager, reducing profit tax for digital asset custodial services under free zones entities. These measures aim to rival Singapore tax that is a very tax friendly regime, and it wants to attract more investment under this management. And last, I can say is that these initiatives like the virtual asset consultate panel and government grant for Web3 research aim to cultivate a local crypto talent pool. This pipeline strengthens the ecosystem, ensuring Hong Kong can support the next wave of DeFi tokenization and NFT projects. And taken together, this demonstrates Hong Kong's dual focus on regulatory rigor and market accessibility, ensuring it remains a leading global hub for virtual assets even as the international standard evolves, securing timely updates and secured. Okay, so that is how global compliance matrix has helped VSPs, uh, Hong Kong VSPs.
Understood, Nikhil. Understood. I completely understand what you are trying to say. Nikhil, so we are at the end of this session. So any final words from you that would help our audience and viewers to just understand the regulations or act that Hong Kong's is using for virtual digital assets?
First of all, only thing I will say is Hong Kong's judiciary is very active in towards these type of regulations, like interpreting this type of regulations, accepting this type of cases, issues, customer behaviors and all. I mean, just in last January, I think a legal notice, a legal notice was published on a blockchain that a particular transaction will not be that a particular hash key, sorry, not transaction, particular hash key which belong to a hacker which has hacked some amount of tokens will not be taken into transactions, and anybody who takes it into a transaction will be uh, produced with criminal charges. So that how much, this is the level of their judiciary, that how much they are active in handling customer centric cases, in their implementation, in their interpretations, in their compliance, and also it's a very good place to start your business. It's a very good place to register yourself, because the compliances are very good. So all that.
Okay, Nikhil. Thank you for being such a kind and informative speaker for our audience and for the viewers. So thank you very much, Nikhil. So with this, we end this session of SecureDApp Spotlight. This was episode 4. Thanks for watching. If you like the video, please hit the like button. If share this video with your friends, families, and colleagues. Subscribe to our YouTube channel, SecureDApp. I will definitely see you in the next episode, in the upcoming episode of Secured App Spotlight. Till then, stay safe, stay secure, and as always, I say, stay ahead. Thank you.